property by will, the law starts with the rule that an individual is entitled to do as she wishes. But since 1938, there has been, by Act of Parliament, a limited power given to the court to modify a will if it doesn't make reasonable financial provision for a defined class of people who were closely connected to the maker of the will. That class includes present and former spouses and partners, the deceased's children, and people whom the deceased was maintaining financially at the time of death. For most of those people, the statute says that the will can only be altered so far as alteration is needed to make reasonable financial provision for the maintenance, which is very roughly day-to-day living needs, of the claimant. That's what claimants have to show. It's not enough for a claimant to say that it seems unfair that the will didn't leave him more than it did. This case was about a claim made by somebody who was within the class of possible applicants. She was the daughter of the deceased. She could properly say that she had need of maintenance because she and her family were living on a very restricted income, mostly benefits. But she wasn't a dependent child. She was a married adult daughter in her 40s, and she had been estranged from her mother, the testator, for some 26 years before the mother died. The testator, her mother, had made a deliberate decision not to leave her anything in her will because of the long and almost complete estrangement. Instead, she had left her estate to charities. So there was a difficult question about what would, in those circumstances, be reasonable financial provision for the claimant's maintenance. Should it be nothing, given the estrangement, or something, given the parentage, and if something, what? The judge who tried the case awarded her £50,000 out of an estate of about £480,000. The claimant daughter said that that was not enough and set in motion a series of appeals which eventually found their way to this court. The Court of Appeal decided that the judge had made identifiable errors of principle, and so it set about substituting its own decision. That decision was to award the claimant £143,000 to buy at a sitting tenant's discount the house where she and her family lived, plus an option to receive £20,000 more in one or more instalments. The appeal is against that decision. This court unanimously allows the appeal against that decision, and it restores the order which the judge originally made. There is a single judgment of mine with which everybody agrees, and Lady Hale additionally gives a short supplemental judgment addressing particularly claims by adult, non-dependent children. And Lords Kerr and Wilson agree with that also. Our principal decision is that the judge hadn't made either of the errors of principle which the Court of Appeal thought he had. And it follows from that that the Court of Appeal had no basis to redecide the case. The Court of Appeal had principally thought that the judge decided the case without appreciating that a lump sum would reduce the claimant's entitlement to benefits because of means testing. It thought that as a result, the judge's order would be of little or no advantage to her because she'd lose in benefits what she gained from the award. In fact, the judge had been very well aware of the benefits rules. He had made his order to give the claimant a lump sum so that she could put decent modern household equipment into her home instead of the very old and totally worn out things that the family was currently managing with. So that meant that the money was for her maintenance, and more, if she spent it in that way, she would not retain a capital sum and her benefits would not be lost. The judgment also deals with some of the rather technical questions about how claims under this Act ought to be approached. There's absolutely no need to summarise all of them now, and apart from what I've already mentioned, just a few will do. First, the judgment deals with how far it is relevant to ask whether the deceased acted unreasonably. The answer is that that's not the main question. The main question is whether the outcome of the will is to make for the claimant reasonable financial provision for her maintenance in all the circumstances. So, for example, if an adult son or daughter has her own independent finances and doesn't need maintenance, the court can't alter the will, even if it thinks that the deceased ought morally to have done something different. On the other hand, the behaviour of both the deceased and the claimant may well be factors which go into the question of what it would have been reasonable to do by way of maintenance provision, and they were here. Secondly, the judgment explains that these cases can't be decided simply by comparing the expectations or needs of the claimant with the expectation or needs of the chosen beneficiaries. The people to whom the testator chooses to leave her money, whether they're relatives or friends or famine relief or some other charity, those people do not have to justify their entitlement by need or by expectation. So far as they are concerned, being the testator's choice is enough. Their claim then has to be balanced against any application made by the limited class of people who are entitled to ask the court to change the will. Next, the judgment deals with whether the very long estrangement was significant in working out what was reasonable financial provision. It holds that the judge was right to say that it was significant. Then the judgment confirms existing case law, which reminds courts that although you can make provision for maintenance by way of a lump sum for either immediate or gradual spending on maintenance, as happened here, it will not normally be right to bestow appreciating capital on the claimant because that goes beyond maintenance. So if housing is to be provided, usually a life interest in the house will be the more appropriate way of doing it. And lastly, the court confirms what is again well-established existing case law, which makes it clear that an appeal will not succeed unless the judge has made some error of principle. Neither side can appeal and simply ask the appellate court to start again from scratch and make a different decision. That's a general rule. It applies to this kind of case as to many others.
The court is now adjourned.